One of the fruits of the current constitution is the Supreme Court, the apex court in the land. 14 years since its establishment under the 2010 constitution, Kenya's Supreme Court has emerged as one of the most influential institutions in shaping the country's governance and democracy. Linda Alela looks at the Supreme Court 14 years down the line.
The Supreme Court of Kenya, born in 2011 following the promulgation of the 2010 Constitution, is mandated to be the country's final arbiter of justice, safeguard constitutionalism, and providing checks and sometimes balances on both political and state power. Established under Article 163, its decision set precedent on all other courts in the country.
And I wish to clarify that judiciary does not exercise overreach. When we interpret the Constitution, we are merely breathing life and spirit to the Constitution. And should there be overreach, it is quickly checked on appeal, and the issues are brought within the four contours of the Constitution.
Over the years, the independence and stamina of the Supreme Court has been challenged to deliver massive rulings that have redefined the nation's democratic setting. In 2017, the court stunned the world when it nullified the presidential election, citing irregularities and illegalities, a first in Africa and only the fourth such ruling globally. Recently, in 2022, the Supreme Court upheld the election of President William Ruto, declaring the process transparent and credible despite petitions challenging the outcome. The court has equally weighed in on critical reforms like the Building Bridges initiative, striking down the constitutional amendment process as unconstitutional, to decisions on gender representation, devolution, and the limits of presidential power. From the reign of former Chief Justice Willy Mutunga to that of David Maraga and now Martha Koome, the court's journey has not been without misses. Critics argue that the court has in times quivered under political pressure. The controversial 2013 decision upholding Uhuru Kenyatta's victory, despite contested evidence, still raises debate. Delays in delivering timely rulings and inconsistency in interpreting electoral laws have also dented public confidence. Allegations of political interference and alignments are bedeviling the bench.
Judicial decisions cannot be influenced by anybody or any authority. Therefore, an independent and well-resourced judiciary is not a privilege of judges. It is a right of every Kenyan and a safeguard for our democracy.
14 years on, the Supreme Court stands at the pinnacle of Kenya's democratic journey, celebrated for its boldness, criticized for its inconsistencies, but undeniably one of the country's most consequential institutions.
As we listen to some of the cases, there are a number of tough wars. You know, some of the cases that come before us, some are between Senate and the National Assembly, others are between the national government and the county government, but those are disputes that we do resolve. However, there is a concern that sometimes political questions are brought to the courts, and courts cannot answer political questions. Courts may only answer judicial questions.
As Kenya celebrates 15 years of the 2010 Constitution, the question remains, can the court continue to balance the scale of justice while remaining immune to the pressures of politics? For TV 47, I'm Linda Alela.